Good afternoon and good morning, and welcome to HUD's webinar on our proposed rule, streamlining requirements governing the use of funding for the Section 202 and Section 811 programs. My name is Ben Metcalf, and I'm the Senior Advisor to the Acting FHA Commissioner on Multifamily Housing Programs. I'm here to welcome you today. Today, staff from HUD will be walking you through this proposed rule intended to aid nonprofits in using Section 2 and Section 811 with other sources of financing. We look forward to your thoughts and your comments on this proposed rule during the course of this webinar, but also encourage you to submit formal comments. Our deadline for those comments will be May 29th. Please do note that this is part of a larger effort to update and reform our Section 202 and Section 811 programs. We're currently working on a second proposed rule, which we plan to release later this year, that will implement several other provisions of the legislative bills that were enacted early last year reforming both these programs, the Frank Melville Supportive Housing Investment Act and the Section 202 Supportive Housing Act. On Section 202, we'll also be holding a listening session tomorrow at 2 p.m. Eastern Time on the future of the program, and I encourage you to join in person or by phone for that as well. If you're interested, please RSVP to brendan.b.mctaggart@hud.gov. On Section 811, we'll be issuing a Notice of Funds Availability on our Project Rental Assistance Demonstration Program, a new authority authorized under the Frank Melville Bill. We expect to have that NOFA out in the next few weeks, and we look forward to your interest and your feedback on that NOFA as well. We understand that there's much work to be done to help provide quality, affordable housing to the growing number of rent-burdened elderly, renters, and disabled persons. And we thank you for your time and attention in making these programs work better. I'm now going to go ahead and turn this over to Aretha Williams with our Office of Housing and Grant Administration. She and her staff will walk you through the contents of this proposed rule. Before I do that, one small note. We are experiencing some technical difficulties with the closed captioning. I apologize for this, but we are working to fix that, and we assure you that the closed captioning will be in place for the version of this webcast that is archived. Thank you so much for your time and attention today. I look forward to your comments. Thank you. And here's Aretha.
Thanks, Ben. As Ben said, we are trying to bring you this broadcast today just to help you walk through the proposed rule that's been published. The purpose of this rule is primarily because we're trying to implement some of the changes that were made in the Section 202 Act of 2010 and the Melville Act of 2010. As Ben mentioned, there will be a later rule that will come out that will provide a little more detail on implementation of those rules. It's also provided to improve the efficiency in administering the programs here at HUD. As a lot of you know, we've had to do a lot of waivers to implement some of the, to assist some of the mixed finance projects in reaching a closing. Hopefully this rule, the things in this rule will help alleviate some of the waivers that have had to be requested. We also are trying to provide flexibility in financing and design options for some of our projects. The rule also is proposed to remove some burdens to attracting private capital and industry participation. We hope that you will pay close attention to the provisions in this rule and to provide us with your comments that will help us in crafting the final rule. I will now introduce to you Shalonda Lincoln, who is a program manager in the Office of Housing Assistance and Grant Administration. And next to her is Andrew Lee, who's with our program attorney in our Office of General Counsel. I will now turn it over to Shalonda.
Good afternoon, everyone. This briefing will follow the format as found in the Federal Register publication. We'll be starting with definitions and ending with drawdowns. If you have any questions, feel free to email me at shalonda.s.lincoln@hud.gov at the end of the presentation. You'll have time to email questions during the broadcast and anytime thereafter. Starting with definitions. One of our proposals, HUD has authority to allow the transfer of responsibilities of an owner entity to the governing board of the sponsor. and this is to be in conformance with the Section 202 Act of 2010. For Section 202 program, the instrumentality of a public body may be an owner or sponsor. However, that instrumentality must otherwise meet the criteria for ownership or sponsorship. An owner must be a single asset entity instead of a single purpose entity. The purpose must include the promotion of elderly or persons with disabilities, but it's not limited to that purpose. For mixed finance owners, the Section 202 program is allowing limited liability companies to be the general partner of a for-profit limited partnership. The general partner can also be wholly owned and controlled by one or more nonprofit organizations. And this is also to comply with the statute change for Section 202, the Act of 2010. For mixed finance developments, Section 811 developments, the definition of an owner has been changed to allow general partner to be owned and controlled by a nonprofit as opposed to the existing language of wholly owned and controlled, and that is in conformance with the Melville Act of 2010. We have proposed to change the definition of repairs and rehab, and we would break that into two different criteria for rehabilitation. The first category would be substantial rehabilitation, and the criteria for that would be improvements to a property in deteriorated or substandard condition that endangers health, safety, or well-being of the residents. The cost must also be greater of 15% of the replacement cost, or $6,500 per unit, to rehab to a useful life of 55 years. You can also qualify if two or more major building components are replaced. The second category would be repairs, renovations, and improvements. That would include any work outside of substantial rehab, but also would include cosmetic repairs below a dollar amount of $6,500 per unit. And these changes are to better conform our definition with other HUD multifamily housing programs. The $6,500 threshold may be adjusted by HUD after advance notice and public comment. We are proposing to make changes to design and eligible uses. The first would be a technical correction to reference the current minimum property standards that are found in 24 CFR Part 200, Subpart S. For excess amenities, we will no longer include balconies and decks, dishwashers, trash compactors, and washer and dryers in individual units. Smoke detectors and alarm devices will be required in any dwelling or facility bedroom or primary sleeping area. And these changes are to conform with current industry standards. For Section 202 mixed finance projects, the restrictions on prohibited facilities apply only to the capital advance funded portion of the development. And prohibited facilities would include infirmaries, nursing stations, or spaces for overnight care. These facilities must not be financed or maintained and operated with Section 202 funds. Assisted residents are not required to pay a fee or use or maintain the facilities. Any fee charged must be reasonable and affordable to all residents. Changes to prohibited relationships. The sale of land between an owner and the sponsor or the sponsor's nonprofit affiliate will not constitute a conflict of interest. An additional change to mixed finance projects, identity of interest between an owner, sponsor, and development team members or between development team members will no longer be prohibited. I'm going to now turn it over to Andrew Lee, who will go over the remainder of the presentation.
Yes, good morning and good afternoon, depending on where you are. Again, my name is Andrew Lee. I'm with the Office of General Counsel, and I'm going to go through the remainder of the slides with you today on the streamlining that's being proposed. The first slide there is going to be the audit requirements. Basically, we are going to remove a obsolete reg. The current reg cites to Part 45, which is no longer in place. We're going to simply cite back to the correct reg, which is now going to be 5.107. Again, the requirements have not changed, only the regulatory language has changed in terms of the right citation. The next slide. is going to be duration and repayment. Duration. The reg is currently at 891.165. The current regs allows the time period to be 18 months. We're going to bump it up to 24 months and allowing it to go up to 36 months at HUD's discretion. In looking at the reg, I went through the waivers for the past 2 years, and the interesting thing is in 2010, we had issued about 70 waivers for this particular reg and 73 in 2011. So again, this is a common reg that we see come through office for waivers, and with this proposed reg in place, the waivers will be done with, and it will certainly help move the projects much faster along the pipeline, rather than waiting for approvals from HUD for waivers. The next reg I'm going to be talking about is 891.170B, which is the repayment regulation. Now again, the focus here is on B. The A has not changed. So the issue with B is that with TPA, transfer of physical assets. And the idea being here is that when you do a TPA, the capital advance units maintain their status quo. There is no change in how those units operate. And again, we want to reiterate that the non-capital advance units are free to do their own thing, without following through HUD requirements. The concern here again is only for the capital advance units. For the next slide. The next slide is going to be about drawdowns. Again, the main theme here is worried about the capital advance units. So there'll no longer be pro rata share issues. What we're going to be doing is allowing the drawdowns to happen first for the non-capital advance funds. And if there is a drawdown, they'll be based upon an approved drawdown schedule. Again, there's no longer a pro rata requirement. Capital advance funds can now be used to pay off bridge loans. To the extent that these units are going to be capital advance units. Again, the idea being that the capital funds units are the ones that we're most worried about in the streamlining. And again, in looking at the waivers that we've done in the past, not as frequent compared to the duration of the capital advance. The 891.830 waivers, we've had about 10 in 010 and about 9 in 011. So again, not as common as the duration of capital advance waivers, but again, the overall goal here is to streamline the regulations to make sure that we can move these projects forward much faster. Next slide. And final slides, again, if there are any comments that can be made regarding how to make these regs better, or you have any other ideas, you can submit comments to the Regulations Division with the Office of General Counsel. The address is on the slide, but it's 451 7th Street Southwest, room 10276, Washington, D.C., 20410. And please include the docket number and title of the rule when you do submit your comments.
We will now take any questions you may have. So if you've emailed questions, we will take a look at those. Also, remember that you can email questions to me anytime after this broadcast. But if you have particular comments, please, as Andrew suggested, use the official method through the Office of General Counsel. The address and the electronic submission website is also found in the summary page of the publication.